Right, so I want to welcome everybody to tonight's Metro DC EDS and HSD support group. We are having a discussion with Elizabeth Gray and Caitlyn Bender on estate planning, special needs planning, medical directives, otherwise known as power of attorney, medical power of attorney. So we should have an interesting discussion, and I will now turn it over to Kendra Nielsen Miles of EDS Wellness, who will moderate for us.
Welcome to everybody. I'm going to go ahead and read bios, and then I'm going to let our two presenters get started. So thank you for everybody being here with us. And we're going to hold the questions until the end. Is that correct, Danielle?
Yep.
Okay. And I think any questions that we have, people can raise their hand and they can put in the chat, and then we can just wait until the end. Is that all right?
That
Okay.
sounds great.
All right, so Elizabeth Gray has been the cornerstone of Virginia's elder law and special needs planning community since she began practicing law in 1996. Known as the go-to authority amongst her peers, she brings a wealth of experience to elder law, special needs planning, guardianships, estate administration, and estate planning. Elizabeth's commitment to her field has been recognized with numerous honors, including being named the outstanding member of the Virginia chapter of VAELA of the National Academy of Elder Law Attorneys, which is called NAELA, in 2011. As a past president of VAELA, she remains deeply involved in the advancing elder law and special needs throughout education and leadership. Her expertise and dedication have also earned her a place in NAELA's prestigious Council of Advanced Practitioners and an invitation to the Special Needs Alliance, a national invitation-only organization of attorneys serving individuals with disabilities. She sits on the board of directors for the ARC of Northern Virginia, underscoring her commitment to supporting individuals with disabilities both in and outside the courtroom. Elizabeth previously co-chaired the Elder Law, Wills, Trusts, and Estates and Practice Management sections of the Fairfax County Bar Association. Caitlyn Bender. Caitlyn Bender is an up-and-coming associate attorney in the Northern Virginia area where she specializes in a diverse array of legal areas, including civil litigation, family law, elder law, special needs planning, estate planning, and estate administration. She earned her honors Bachelor of Arts with distinction in political science from the University of Delaware, focusing on law, politics, and theory, and minoring in history, and legal studies. Her thesis, Juvenile Recidivism and Policy, published in 2018, reflects her keen analytical skills and passion for justice. Caitlyn continued her legal journey at William and Mary Law School, where she distinguished herself as an executive editor of the William and Mary Bill of Rights Journal and took on leadership roles in the Women's Law Society and the Public Service Fund. Her commitment to public service was further exemplified through her work as a student attorney in the Domestic Violence Clinic and her internship at the Justice Chafin, is that correct?
Chafin, yep.
Chafin at the Supreme Court of Virginia. With a solid foundation in both practical and theoretical aspects of law, Caitlyn is honored to represent clients of various needs throughout Northern Virginia. She was named one to watch in the elder care field. So thank you both for being here. We look forward to your presentation. Thank you very much.
Thank you so much for having us, and lovely introduction. It's great to be here with you all. I'm going to go ahead and start sharing my screen here. So this is a presentation that I've kind of called Empowerment Through Planning. And that's something that we really strive to do. Liz and I are both really, we feel very strongly about the education part of our job. It's not just what you know, it's, that you need to know all of these different things about the law, and it can be incredibly overwhelming. So we try to educate everyone on how to best deal with that, and the different issues that everyone faces. So I know we're going to do questions later, but one question I have for you all is who has a will or an estate plan of any kind? And so we'll see, I see a few hands raising. That's always great to hear that, because we're often surprised that people don't. And so that's what we're here to talk about, whether you need one and what are the pros and cons of having one. is one of the main things that we'll be discussing. So what is an estate plan? One of my biggest pet peeves for lawyers is we all speak our own language. We call it legalese. And so we use these legal terms and we don't really define them. And I find it really frustrating. And I'm sure our clients do as well. So one of the terms we'll be using over and over tonight is the estate plan. I'm very sorry if you can hear my dog in the background. He's decided to run around my place now. He got very excited when he started to hear everyone talk. So but an estate plan is something that we often kind of talk about in a very vague or nebulous way. So, an estate plan is a compilation of documents that helps plan for incapacity and what happens to your assets after you pass away. It's generally comprised of a will or a trust, along with what we often call ancillary documents, although they're not that ancillary. There goes my dog. And the main things we think about with estate planning is legacy planning. Who do you want to contribute to after you've passed away? More than just family and friends, which is what most people think of. It's Trunk and not taken away from him. But it can also be charities, churches, educational institutions, things like that. Right on par with that is the family harmony. Sometimes it is an issue as someone who works in estate administration, and I litigate estates as well. I know when someone passes away, that grief often presents itself in sometimes the worst of ways for people, and it really creates a hard time for families. And so having something that is clear and written out can help alleviate that. We also, a big pro of estate planning is income tax planning and asset protection. There's many things we can do, particularly that's coming into our field a lot right now as the estate tax, the federal estate tax limit is set to sunset soon. So that will bring it from about the 12 million it is now down to a level other people may achieve. I always say, if you have an estate tax limit problem, you have great problems to have. I aspire to have that. And then finally, and maybe most importantly, to you all is incapacity planning. I think a lot of people think about estate plans in terms of what will happen after I'm gone. But the reality is we can do a lot of planning of if you're still here, but you're unable to make decisions for yourself. This is something that I deal with personally a lot. My grandparents are in their 80s and are not making the best financial decisions that they once were able to make. And so this is something that now we're able to step in and help them because they had the planning that they needed. And we never had to get the court involved or anything like that. We're just kind of able to seamlessly step into their shoes. And so this is kind of an underrated pro of doing an estate plan that I like to highlight as well.
I think, Caitlyn, that was very positive. Caitlyn and I are really jaded because we see the absolute worst in people. And it's hard sometimes to come on and be positive about estate planning, but that's because we've seen it all and it's not good.
No, it can get very ugly at times, and I won't bore you with my estate litigation stories that I am going through at the moment. And while it's great for lawyers because we make big money doing all of that stuff, it's not what I would wish for anyone to have to go through. And it is a very scary thing, so I try to paint the positives because no one really likes to talk about this stuff except for Liz and I. So a big question I get is what happens if I don't have an estate plan? And it's an excellent question. It's totally fair. So the first thing is the state will figure out what to do with your assets. The state has a big long list that Liz and I had to memorize a long time ago of who gets what and how it passes. And it may be confusing, it may be not, depending on your own personal family situation. So, don't worry. If you don't have one, the state will figure it out. But that's not generally what people want to happen. And even if your plan follows a very similar, your spouse and then your children and then your parents and then everybody else in your life, it can also cause problems to not have one in ways that people don't think about. Because even though the state's going to deal with it, you may become incapacitated. And like I said, for example, with my grandparents, if my grandparents hadn't had an estate plan, we would have had to go to a court. We would have had to hire someone like myself or Liz, to help us with that, go to court and file to get a guardianship or conservatorship over them, which means lots of excess doctor's visits to get that taken care of. I standing in front of a judge, which is nobody's ideal Wednesday except for maybe mine. And that way the judge can appoint me. And that also means for weeks at a time, no one's managing their finances. The same thing, God forbid, should someone have been in the hospital and you don't have an advanced medical directive, which is a document also called the healthcare power of attorney or things, living will. There's lots of kind of names for it. But again, that can be hard to do when you know you have major medical decisions that you need to get done. And those decisions need to be made quickly. Also, if you don't have an estate plan on top of the state figuring out what to do with your assets, it will also charge you for the privilege of having that done. The probate tax in Virginia is 10 cents for every $100, but that adds up faster than you'd think it would. So there are many consequences that people don't necessarily think of, on top of, not having the specialty planning that people may think of with trusts, but also kind of the everyday things that people go through, even when you're still living. Another thing to consider when doing an estate plan is what assets will that actually affect? Because there are assets that avoid probate, which probate, again, I'll try to define the legalese, is the process that you go through with the court of the county where someone passes away. And that is kind of the overseer if you don't have a trust. If you have a trust plan that exists outside of probate, as long also with beneficiary designations. So anything you own jointly at the time of your passing avoids probate. A probate asset is only something that is in your sole name when you pass away. Now, there's a cautionary tale when it comes to this because I often say this and people will say, well, I'll just put my kids on my bank accounts. And Liz is already laughing because she knows the answer to this too. It's a calculated risk because while anyone you have jointly on the bank account can access the accounts right away, which might be fine because you may already be having them help, as is the situation with my grandparents. We were already kind of helping them, although we were not joint on the account for the following reason. And that then after they pass away, whoever is on the account with you inherits the account in the entirety. And that's not something that most people want. They consider that part of their estate and they want it divided kind of equally amongst whomever. It also exposes them to capital gains tax if it's or they avoid the step up in basis. So if it's that kind of asset, there can be tax implications. And even if it's not something that you're worried about capital gains on, it is something that you can have gift tax because that individual may feel the need to, share it amongst their, siblings or whoever that, the deceased would have wanted them to share it with. And so they may incur gift tax as a result of having to pass that out. There's also a big issue with real property. I'll just put my kid on the deed is something I hear quite a bit. And that also incurs problems. I have a case going right now where I will have to likely file a partition lawsuit because someone put their stepson on a deed and now they need to sell the home to go into assisted living to have more care. And now stepson won't agree to sell the house. So we're going to have to get the court involved, which is a big, long, and expensive process. So she won't be able to get the care she needs right away.
There's a famous Virginia case where dad put daughter's name on the property for convenience purposes, which a lot of our clients say. And then he sold the property and he kept all the proceeds and she sued him because he put her name on the property. She was entitled to half the proceeds. And the court said, absolutely. When you do joint tenants like that, you are only entitled to half. Now, that probably ruined the relationship between dad and daughter, can imagine. But things like that. Or if you're putting your adult children on property or bank accounts with things like that, it opens up that bank account to your child's creditors or if the child's getting divorced, all kinds of things like that.
Yeah, so there are many, many cautionary tales, unfortunately. We wouldn't have jobs if there wasn't. But it is not something that we like any of our clients or their families to have to go through. And so that's why we always bring this up. But there are things like retirement accounts or life insurance that you can have the beneficiary designation on. And if you successfully complete that paperwork and the institution doesn't lose it, which is a situation I'm dealing with at the moment, then it will pass outside of probate. So those are other tools that you can do to avoid probate in larger assets, like, for example, retirement accounts tend to be. So when you meet with me and start talking about your estate plan, we'll have lots of conversations about your family and things like that. What you want, your personal situation. But the first big decision that I ask people to make is, to quote, to be or not to be, to will or not, or to trust. My simple try to do that. So a will and a trust, what makes them different? So the biggest are the wills avoid probate. So that means two big things. You don't have probate tax, which in Virginia is again 10 cents for every $100. And they're
You
private.
had a typo, Caitlin.
Oh,
or
I did?
Yeah, you said wills avoid probate.
Oh.
And I know you didn't mean that.
Oh, no. Yes. Wills go straight to the probate office, and they become public record, which is something that I've had my own personal experience with. My aunt passed away and had only a simple will. And because it became public record, I guess there are people that just look at the land records to see people that have recently passed away. And because of that, they had a connection to my aunt and tried to sue her estate in an attempt to get any kind of payout with a bogus claim. And unfortunately, this is something that happens. And so a great way to avoid that is a trust. So a trust avoids probate and therefore is private. It does not become a public document. Liz also has experience, and I've heard from her of when you have special needs trusts or things of that matter, having them in a will exposes that to the public. So anyone could go down to the courthouse, look in the land records, or go online these days and look at the land records and see that so-and-so has a special needs trust. And that, again, opens them up to scammers and the like. So those are some of the big reasons people consider a will versus a trust. There's also the asset protection. And people have, more complicated situations, or if they have, more unique or complex issues they want to deal with within the trust, then we often advise a trust to do that. So that's the big first decision. But again, whether you do a will or a trust, there are other documents that are going to be within the estate plan. So what are these other documents that we're talking about? The first is the Advanced Medical Directive, which we also call the Living Will. This is a great document, particularly for people that have health concerns moving forward, because it really sets out your wishes clearly. There are so many, questions that we ask about everyone's wishes. Most people are like, whoa, I've never even considered this. Whether you would like to have food and water, if you are in a persistent vegetative state, things like that is something we'd ask you. It also authorizes participation in medical studies, and we differentiate between medical studies that would benefit you, medical studies that would benefit just the world in general. So we can really get some detail and give clear instructions for whoever's going to have to make that really difficult decision, because that's maybe not something people have talked about. I think people talk about, organ donations or things like that, or whether they would like to remain in a persistent vegetative state or be taken off life support, as it were. People have these kind of high-level general questions in conversations with their loved ones, but when the doctor asks you more minutia, it's really wonderful, I think, to be able to reference this document.
Or secondary illnesses.
Exactly, yes.
there's a really great web page, and also she's on LinkedIn, and it's Dr. Brittany Lamb, and she is an ER doctor who goes over how to do an advanced directive that doctors can understand. And so I highly recommend, if you do want to figure out what you need in your advanced medical directive, to look her up on LinkedIn or Google her. But she's really great.
Yeah, I think that it's so important. I talk about people not being able to understand our legalese. I've two of my best friends are doctors. I have no idea what they're talking about half the time. And so kind of being able to bridge the understanding gap between all of that, I really love her work. And I'm really grateful that Liz introduced me to her. So I think that's an excellent resource for everyone. So the next, or another document that you do is the financial power of attorney, durable general power of attorney, as we call it. So this is an interesting document because it's purely for while you are living, and it allows someone to immediately step into your shoes to handle your financial documents, your financial decisions, your accounts as needed. Now, if you chose the trust route, there will be accounts that we have you put into the trust. Fund is another legal word we use. And so those will be in the name of the trust, and therefore the trustee will be responsible for dealing with those. So when making this decision, if you've decided to go the trust route, we often recommend that this is either the same person as the trustee or someone who is comfortable working very closely with them. We also always recommend that while we love many of our family members and our friends, not everyone's great with money and financial decisions. So you need to pick someone that is financially savvy, and who is going to be able to keep track of, all of your bills, be able to, sign you up for Rocket Money so you know which subscriptions that you have and can be canceled, something that I need to do because I have too many. And someone who is going to really be able to handle this task because it's an important one and it can be overwhelming. So this, and you're avoiding going in with the judge and getting the guardianship conservatorship, and just lets them seamlessly step in and start handling that day one that they need to.
One of the things that Caitlyn and I get all the time is that the person will come in and say, I don't want my power of attorney to be effective until I'm determined to be incapacitated. And we hate those because it's really difficult to get a doctor to say, my patient is incapacitated.
Yeah.
And they'll want to refer you to a neurologist, which will take 6 to 8 weeks or several months to get in. And the neurologist isn't going to just say, oh, you're incapacitated. The neurologist is going to want to do a whole bunch of testing. Meanwhile, your agent's hands are tied.
Yep.
So we always tell people to pick the right person. If they can't balance their own checkbook, believe me, they will not be able to balance your checkbook.
Yes, absolutely. And yet, in the age of digital statements, we've somewhat made it harder on ourselves. So maybe someone who's even a little digital savvy and can break into your email. Okay, so that concludes our broad overview of estate planning and why we feel that estate planning leads to empowerment in these situations. I hope you've been able to take away that, this enables decisions to happen quickly, should they need to. And now we are going to talk about special needs trust. This is something we understand that this is a big concern, that my understanding is this is kind of a genetic condition, and therefore a big concern for families. And this allows for future planning, and all of that. So we'll talk now about, we're going to pivot into special needs trusts, which heavily overlaps with estate planning because that's the mechanism that we use for this. So we'll just start broadly again with definitions. I love a definition by now. That what is a special needs trust? A special needs trust is a mechanism that we create through estate planning that allows a beneficiary who is qualified for benefits to the government, whether it be Medicaid or SSI or what have you, and allows them to maintain that qualification while having this other pot of money that will help them should they need it. Because we are often aware that the Medicaid and other government benefits are not sufficient, particularly in an area like Northern Virginia, where everything is way more expensive than it should be. There are 3 typical types, and I'll talk about these briefly. There are 2 types that you would meet with someone like us to create. Third-party special needs trusts and a first-party special needs trust. And then the big difference in my, how I view it is a third party and first party is just who is contributing the funds. If the beneficiary of the special needs trust has their own savings and is trying to qualify for benefits, then a first party special needs trust is really great. And that's something that we could set up.
Only until the age of 65, however, in Virginia. Some states allow you to do after age 65 for pooled trusts, but first party trusts you have to do before the age of 65.
Correct. And Liz can correct me if I'm wrong on this, but the first party, it doesn't necessarily have to be set up by the person with the disability. It can be set up by a parent or a grandparent or whomever. But the funds of the beneficiary is the same as for the beneficiary is the same as the person with the disability. And then the third party is the same kind of concept where it's something written by an attorney specifically for the benefit of one person with disabilities, but it is funded by third-party money. So parents, grandparents, friends, other people besides the beneficiary contribute assets to that kind of trust. And then we
get
also
a lot of people asking, well, what does it pay for? Well, Medicaid and SSI only pay for certain things. You use a special needs trust, and I've used one in certain situations. Number one, to get a secondary doctor's opinion. I was guardian for a gentleman with Down syndrome, and he didn't understand that his hip needed to be replaced, and the doctors just figured it was too much trouble. So they were just going to remove his hip and make him wheelchair bound. And I really didn't like that idea. And they were like, too bad, that's what the doctor said. And the doctor's a Medicaid approved doctor. If I had had a special needs trust, I could have gotten him a second opinion or a third opinion, or even used a different doctor than the Medicaid doctor for that decision. So that was a really sad case in my mind because he didn't have any of those things and there was nothing I could do. But it could buy, I had one case where we bought a Wii Fit back in the day when the person wanted to start exercising, and we've used it for buying a car or a home even. And paying for non-prescription medications, certain foods, things like that.
Yeah, so there's lots of applications for funds like this. And so being able to plan in advance and really, again, going back to the theme of this, empowers that person to make other choices outside of, for example, what a Medicaid doctor would have chosen for them. Liz, do you want to talk about the pooled trusts as well?
Sure. So a pooled trust is a statutory animal. It must be run by a nonprofit, and the nonprofit administered the pooled trusts. A pooled trust is sort of like, it's called pooled because they pool all of the money together for investment purposes and to keep costs low, but each person has a separate account. And it is sort of like a bank account. You open up an account, the bank unfortunately has all of our money and they earn billions of dollars on our money, and we only earn a little bit. But that's the same theory with a pooled special needs trust. Each beneficiary has their separate account. The nonprofit administers it. And so oftentimes the pooled trusts will take lower dollar amounts. So if you are leaving in, 10,000 in trust. Let's say you want to leave $100,000 in a special needs trust. You're not going to be able to find somebody to administer that that's a professional for such low money. And I have a big problem recommending family members to serve as the trustee in a special needs trust situation because I see all of the horrible things that happen, and oftentimes there is nothing I can do. And so it's a really good option.
Yes, absolutely. And it also helps with kind of the burnout we talked about with the general durable power of attorney, how you have to have someone who's very financially savvy, someone who knows kind of what's going on. And that if you have someone that is dealing with government benefits, they're disabled, that can kind of be compounded if parents tend to try to pick the sibling. And that really creates hardship within the relationship often because now they have this additional financial responsibility on top of any caretaking responsibilities that they're taking on. And so we often talk about caretaker burnout and how that can be tricky. And this is just one step to alleviate a part of what's going on.
I'd have to say, over the years doing this, the only cases I see on special needs trusts have to do with a sibling as the trustee for a special needs sibling. It doesn't work out well. It usually doesn't, and it's a bad idea. That's all I'm going to say.
Try and keep it somewhat light. Okay, and so we've talked a bit about the pros and cons as we've seen them, and this is a much more dense PowerPoint than we, sometimes typically, and there goes my dog again, use because we want to be able to provide you all with the best information. So I'll provide this to be sent out for everyone because I know I talk fast and probably click through even faster, so you'll be able to see this. But we've talked about kind of the pros of a pooled trust versus a standalone. Again, the standalone being the first party or the third party trusts that are written by an attorney. There's also, shockingly, also cons to each. And so, Liz, you also want to talk about ABLE accounts?
Sure. ABLE accounts are, there are 529 savings accounts for people with disabilities. And it is a way for somebody with special needs to save some money. It's modeled after the 529 college saving accounts, and they're a great tool that works really well with special needs trusts. So in order to qualify for a special needs, for an ABLE account, number one, you have to be under the age of 26 before turning 26. It's supposed to change in 2026 to 46, and I don't know where they got that age, but your disability must have been diagnosed before turning 26. You can be 56 if you want to open up an ABLE account, as long as your disability was diagnosed before turning 26. The criteria is that you have to meet the criteria for Social Security's SSI or SSDI benefits, or you can get a doctor to certify that the person is disabled, and if they applied for SSI or SSDI, they would qualify based on their condition. And that's all I'm going to say on the qualification criteria for it. In an ABLE account, you can only put in the maximum federal gift tax exclusion. So for 2024, that's 18,000. Each year you could put in 18,000. I believe in 2025, it's going up to 19,000. Contributions to an ABLE account can be by anybody. A family member can put money in there for somebody. A charity, we right now have a GoFundMe page that somebody's going to put the money into an ABLE account. And the contributions are not tax deductible, but the income earned in the account is not taxed. It's tax free if the money in the ABLE account is used for what ABLE says is a qualified disability expense. So a qualified disability expense is housing, food, living expenses, all that kind of stuff. I will tell you that we met with the Virginia Able person over the summer, and I had always been telling people you can't use an Able account for recreation or vacations because there's nothing in that list that says that you can use it for that. But the Virginia Able attorney has a very liberal attitude, and she says that's fine, that's okay. So I tell people right now it's fine. If she stops being the attorney for Virginia Able, I would just make sure that the new one agrees with the current attorney's interpretation of the law. If you work, you can add in more than 18,000. You can add in a certain amount of contributions from your salary. And it's essentially in 2024, 15,060. Or whatever your compensation is for a part-time job, whichever is less. People that put money into an account for somebody else, if they're a Virginia resident, they do get a tax credit. And I think that's all I want to say about that piece. How do they impact benefits? So in an ABLE account, the first 100,000 is exempt from counting for SSI. Once the account goes over 100,000, then SSI gets suspended. It's not terminated, it is just suspended, which is a real huge relief because if you have SSI or SSDI, you already know how complicated the qualification criteria are in the applications. So SSI is suspended, Medicaid continues, even if you've got over 100,000 in the ABLE account. Medicaid continues until the account reaches the state's maximum amount for a 529 college fund. And right now that's 550,000. So if it goes up to 550,000, not only is SSI terminated, but then Medicaid will also terminate or suspend. But if you think about it, at 18,000 a year, it's going to take, at least 25 years to get up to 550,000. So a lot of people utilize these accounts so much that there really is never a problem with it even reaching 100,000. And like I said, it's a really good tool that works really well with special needs trusts.
Okay. So this is just some kind of other general information. I don't know, Liz, if you want to go through any of this or if we want to start taking questions, because I don't want to take up too much time.
I know. I was thinking that we should probably go over the questions that we were sent ahead of time.
Absolutely.
And if people want more information, but we're sort of running out of time and I don't want to bore people with that.
Absolutely.
So
Okay.
did you all get the questions? Thank you so much for your presentation.
Oh, no problem.
Thank you for being mindful of time. I'm usually the one that's like, it's certain time o'clock. How are we doing? So you guys beat me to it. So I have some questions here that Danielle sent too. Did you all receive the same ones? So do you want to I can either read them for you or you can read them yourself and answer them, up to you. I can either help moderate or I can just be in the background and let you do your thing.
I personally love a moderator, so if you'd like
Okay.
to.
All right, I'm happy to read them. Okay, great. And thank you so much it's funny that you guys bring this all up besides having EDS myself, but also my father is almost 83 and he's was so with it and so amazing, but he's also watching, our my sister's in-laws. It's pertinent timing for those of us that have parents that are your grandparents' age. So I know
Yeah. No, it absolutely.
and I'm learning by it going, oh crap, I don't know that I have any of my stuff together at all. So this really very, very interesting, especially those ABLE accounts is very, very interesting. Okay.
Yeah, they're great.
And let me just say that if we don't get to the other slides, we will send the slides out so everybody can see the information that they did not get to.
Absolutely.
Okay, so somebody said, what claim does she calls it narcissistic personality husband, who I'm currently divorcing, have to my disability monies that I've saved over the years? So let's just put it, she and her husband were together. They're currently divorcing. She saved some of her money from disability. So what right does a husband or a partner have to disability money saved?
Sure. I can talk about this a little bit. The answer, which I'm sure Liz and I will both say quite a few times, is it depends. It's a lawyer's favorite answer. A lot of it is fact specific. If you're currently divorcing and you're using an attorney, I'm sure they can walk you through various facts about it. Or if not, feel free to reach out to us. The main fact is when the disability money came in, if any of it came in before you were married, then it can be considered separate property. But any income, including disability, that was earned during a marriage is community property in the Commonwealth of Virginia. And so, barring a prenup or a settlement agreement, which can be done post-nup or in conjunction with the divorce, it's often how we settle divorce cases, then the likelihood is that they are entitled to some of it. It's equitable division in Virginia, so there's lots of formulas that we use to determine the exact amount based on how
And
much
that's
it's
pretty
grown.
much the same in Maryland and DC, if I'm not mistaken. Is that right? Or it could also change based upon the state that you're in. Just I'm covering the states that we all probably are in.
Sure.
Yeah.
I can only speak to the Commonwealth of Virginia. It's the only place I'm licensed. So I'm not sure about Maryland and DC, unfortunately.
So check with the lawyer of the state.
Yes, I definitely check with the lawyer. More facts are better than less in any divorce case. Unfortunately, I pester my clients to death when I do divorces about that. So
All right.
I know them
And
better than
and
I know
just
myself.
remember that Virginia is not a community property state. Um, and if those checks came in and you never put them into a joint account, you never use them for a marital thing like to pay the mortgage or buy food and groceries, it's totally separate, then I believe you would have a really good argument that that is your money and not your spouse's, and doesn't have anything to do with the spouse.
Yeah, I think the main hinge point is where it is and if it's qualified as income in that state.
All right. To be discussed with your lawyer and based upon the state that you live in.
Please do, yes.
Okay. All right. How do you establish a revocable living trust without breaking the bank? They seem to cost $3,000 to $5,000, which is a lot for someone on disability facing a lot of medical bills.
Yes, it is certainly a daunting expense. I think firms like ours, and I'm sure others, do a payment plan in order to kind of make it more manageable to the extent possible. I think, we get the comment a lot of, well, LegalZoom will do it for $1,000 or whatever they're charging these days. And there are pros and cons to that. We practice in this every day. Liz and I can tell you all the whole horror stories, all the pitfalls. And so there's a cost associated with something like that. But as
We tend to call it legal doom instead of legal sin.
yes, we do. Mainly because our firm was just in at the Supreme Court of Virginia, litigating what one of those documents meant that was generated by one of the online things for, I'm sure, $700 or whatever it was, which is still significant, but then they had to pay all the litigation costs for it. And that's something we kind of see over and over again is the cost, and it can be dispersed with the payment plan, is worth it over time because these documents will save you in the end, whether it's probate tax, whether it's paying for a guardianship and conservatorship, which can be incredibly expensive, or not incredibly, but comparably expensive because you're going in front of a judge, so that is automatically just going to take more time. I think it's really just cost shifting. When can you deal with it? And how do you want to deal with it? Do you want to have your loved ones dealing with it? You dealing with it?
And
It's an
I
individual
think that
consideration.
I think that a lot of people don't realize the impact and the implications of the choices that they pick on a lot of these forms. Um, we had one where it was a relatively young couple, and they were my neighbors. And she came over and asked me how I thought about one of these programs, and I said, I love them. I make a lot of money on the mistakes you make. And so she said, well, let me show you what I have. And she showed me hers, and she has her father-in-law as the trustee of her trust when she dies for her and her kids. And I said, well, what happens when you remarry and father-in-law is not that happy with new spouse and doesn't want to use any of that money for you because it should go to the kids? And she hadn't realized that that's what she had done in her documents. So I would be really careful, especially if you have a special need that you need to protect all of your stuff from. Why not just spend the money, do a payment plan? I know we have different rates at our firm for different attorneys. Newer associates charge X dollars and we charge X. So you could probably find somebody, and also the pooled trust companies don't charge a lot for the setup fee for a pooled special needs trust. But you have to remember you need your other estate planning documents because you have to have some way of that money in your estate to get into the pooled special needs trust. So we get a lot of clients that come in and say they have a special needs trust with Commonwealth Community Trust. And so they're all set. And I'll say, how is the money going to get into that special needs trust? And they have no clue. And that's because they haven't done the real planning piece, which is how do you get that money in there?
Yeah, I think the main uh pro, if you want to call it that, of having an attorney that's working with you and knows your family and your situation is we, if you can't tell from Liz and I talking, loves to talk about doom and gloom. We will ask you every hard question that you never considered of, plan Z goes awry and you have to start going into, plan one, how you want to handle it, and we can draft to do that. So that's something that you're not going to receive. On top of, understanding the terminology that's very complex. Uh, you're not going to receive the like, okay, if A, B, and C goes wrong, what's plan D, which is something that we do.
Well, I guess that kind of answers the second part of the question, which was, does cost depend on how complicated or involved a trust is? I guess you kind of answered that.
It does somewhat, yes.
How best to ensure all your assets, including real estate, are properly set to go in the trust and sources of forms for doing this.
I
Yes.
love this person.
I do too.
I don't know if it's
Actual
one
steps.
person, if it's a couple, so I'm not calling anybody out. I'm just, it could have been, not sure, but
We
yes.
love anyone that will fund a trust because the amount of times that I've got, brought in administration, I'm sure Liz is too, because we write this trust and it's beautiful and it talks about every plan under the sun and it's so clear. And then no one puts the money in the trust. Put the money in the bag, put the money in the trust, you have to fund it. So I love that they're already thinking about that. And there's lots of forms, we'll tell you to contact your bank, we'll tell you to contact retirement accounts, insurance, everyone under the sun. We write deeds into the trusts if that's the appropriate estate plan that you're doing. So that's included in our services, but also included in our services is a nice packet of paper saying, these are the assets we think you probably have, and here's how to handle it. This is how to title it. And so we're big into funding the trust. Please don't hire us to do it later for you.
And I guess you're never too young to think about doing this. Am I right?
Yeah, you never know what's going to happen. I hope I never have to use any estate planning documents, but it's also great to know that, if I go and have surgery and something, God forbid, were to happen, that, my family could take care of it. And because it's not just, at passing, there are plenty of life's little mysteries that happen in between then and now. And so it's nice to know that, someone has the money to take care of my dog.
And
He's
and
very
people
expensive.
hate the funding piece because it's hard and it's complicated. And we used to, back in the 90s and early 2000s, we did it for our clients, except that the lobbyists didn't like that, the financial institutions. So we can't do that anymore. But like Caitlin said, we do a chart so you can check off when you did it, and we harass you about it. We want you to fund the trust. Why pay $3,000 to $5,000 if you're not going to do the work to get it funded properly?
Exactly.
I guess my husband and I have a lot to do.
I'm sure everyone's making little mental
The friend that
checklists
was
to
a
go
family
on.
lawyer that did it when I was 26 and we had our first son. And I was like, do I have to update that? No, you're good. Well, we have 3 kids now. We're older. We don't really have a
Oh,
whole lot, but we have a house.
Yeah. You probably don't
Yeah,
even want the same guardian for the kids anymore. So yeah, you gotta look into it.
all these things. Okay. Going on to the next question. Somebody said, I see commercials for trustandwill.com, which was about $800 with access to an attorney and a couple of other online companies that do trust and wills. If one has a fairly simple estate planning, what do you think about online companies? Now, you touched this a little bit, but I'm going to go ahead and read it again. Are there any advantages besides cost that, as well as disadvantages in the hazards? You already talked about this a little bit and a lot, and we know how you feel, but go ahead and maybe expand. Is there any benefit to maybe considering one of these companies?
I can't think of one. Like I said, the state will do it for you, so that's maybe a better option. The
either
state
you
is much
pay us
more clear.
now, yeah, either you pay us now or you pay
Right.
us later a
Or you
lot
pay a
more.
lot and the headache and hassle and things you never
Yeah.
Yeah.
thought that you'd ever think about. Like the person that you were saying about your aunt coming in. I texted my dad and my sister that right away. I was like, oh my gosh, that's crazy.
No, it's super unfortunate. And luckily, my parents are pretty savvy themselves, and
Yeah.
have
I
known
was like, yeah.
Liz for a long time and other attorneys, and were able to take care of it. But God, I mean, it made. I heard the story. She passed, when I was 2, so I wasn't involved in the time. But I heard the story, and I said, people need to know this is just another
Oh,
scam. It's another, prince in Somalia that's needs the help. It's just another way to do it. So I think. Um, Having that and the clearness to go back to your the legal doom question of we don't like it, but the the clearness that comes with this uh can really help, and it helps you think through things. So there I think there, and also as a civil litigant, and someone who litigates estate planning issues, I can tell you that the legal Zoom Doom, the Trust and Wills, I think you can even get them at like Staples now. I saw them where you can just like go online and fill out this form. Even if it's simple, there are vagaries in all of this, and because they guarantee that there's a Virginia attorney involved, doesn't mean they practice in this area and they know the pitfalls, which is our favorite because then we get to litigate it, and that takes up a lot of my time and therefore a lot of money from the client.
And I just want to address one thing that the question has in there. If one has a fairly simple estate planning, there there is no simple estate planning. People always say that, and then when you start asking them questions, it becomes more and more complicated. And so if you don't have kids and you don't have any siblings and you say, oh, mine's so simple, I don't have anybody. No, that's not simple because that means that we are doing something, a charity, an animal, a pet trust. All these things take a lot of expertise to do them well and do them correctly. And especially if there's someone in your family with special needs.
Mhm.
Not all attorneys do them well, and not all attorneys do them. But there are plenty of trust and estate attorneys that'll say, "Oh, I can do a special needs trust," and they do a third party for a first party or a first party for a third party, and gum up all the resources. So you really need to make sure that somebody has experience dealing with the special needs and the special needs trusts.
what deems special needs? Because just off the cuff of my head, I know a lot of us have EDS and different conditions that are associated with it. Some of us are on disability, some of us are not on disability, some of us can work and some of us can't. But there's other conditions that go with it. And the first thing that just popped up from the top of my head is, juvenile diabetes,
Mhm.
type 1. that runs in my family. I don't have it, my kids don't have it, but my nephew does. And my nephew is capable and going to school and, but in that situation, like, is that considered special needs if like if you're a parent or you're somebody that, or you have it, is that still considered special needs even if you're not disabled or on Social Security disability? Is that still within the,
It could be. So if your nephew, if you think he will be able to work and earn money and be
well, I don't trust
self-sufficient,
the health insurance of the government, like, I mean, who knows at some point, and this goes with any of us with EDS too. I mean, like, who knows at some point where we could not have prior
right?
care.
Yeah,
It's one of those things I always think about, and not necessarily specifically talk about my nephew, but I know that a lot of us are in these situations where we have this condition, we have five other ones, but what is the one that considers, you know, under special needs or not, but that's just one that's like, insulin to live.
sure, sure. And my son has Crohn's, and
Right.
the medication is $20,000 every 6 weeks. And if we didn't have good health insurance,
Right.
it would be horrible. But there's no harm in doing one as a
Yeah.
just in case.
Yeah.
And the difference between a regular trust and a special needs has to do with the trustee's discretion on how to use the money.
Okay.
So for a regular trust, the trustee is required to use the money for the beneficiary's health, education, support, and maintenance, and that's considered an ascertainable standard for IRS purposes. But that's what the norm is. So if the trustee is not using the money for those things, let's say the trustee refuses to pay the rent for the beneficiary could go to court and say, look, this is supposed to be used for my support and maintenance, and he's not using it for my support and maintenance, then he would probably win. But with a special needs trust, the trustee generally has 100% discretion to say yes or no. And so if
Okay. So there's not a
somebody,
list of conditions that you have to have or you don't have, like, does EDS fall in the special needs, list or not? I mean, we're talking about it, but how do we?
I think that if you think that Medicaid, a waiver, or Social Security disability or SSI might be in the future, then definitely you need one. But it's one of those hard things to figure out, and um, so that's some of the thing that Caitlin and I do is
Right.
talk through this and see if this person really does need a special needs trust as a just in case, or can we get away with a regular trust?
Again, another benefit to hiring somebody and paying the money and figuring it out versus a form.
Exactly,
For
exactly.
people with EDS or juvenile diabetes or Crohn's, like you mentioned, or all the other 50 million things that we could have that are associated with it or we don't know yet.
Exactly.
Yeah, true.
Um,
Well,
let's
I
see.
have just one quick question. Um, when you do a trust, do the beneficiaries, are they informed that they are as part of the trust? Or is that required? Or
It's
does
not,
that
Yes.
depend on each state or various things like that?
So Virginia is a uniform trust state. A lot of the states have joined the Uniform Trust Code. And what that says is if I do a trust and die, then the code says that you must notify the beneficiaries and tell them that they are beneficiaries of this trust.
yeah.
Do you
So
need to tell them before you die?
no,
No,
Okay.
while you're
Well,
alive, it's private.
exactly.
okay. And when does it become irrevocable? Is that when you die? Or if there's more than one person on the trust, um, if you die, the other person cannot change it?
It depends.
Yes.
Okay.
It depends on how the trust is drafted. We do joint trusts for example, married couples all the time. So that's something that we would discuss with the client of, for example, in cases where there are children that only belong to one of the spouses, then that's something that we often consider of if, the trust is going to benefit the kids, then after one parent dies, is it make sense to make it irrevocable? So it depends on the drafting there. We can do it lots of different ways.
Okay. Well, I want to thank you both very much since we've hit our hour that I had said that we would take up your time. So we had a number of people sign up who I know some couldn't make it, but I had a lot of requests for, oh, are you recording this? Are you recording this? So we will get this posted. And if you don't mind, post it also on our YouTube and our Facebook page, but I can talk to you later about that. But thank you again for all this information. And if anybody has any questions, just go ahead and email me and I can, if it's okay, forward them on or anyway, thank you so much.
You're welcome. It
Thanks
was
so much
good
for
to be
having
here.
us.
Thank you both. We got through all the questions too, so
Oh,
thank you.
Oh,
good.
great. Perfect. Yes. Well, if any others come up, feel free to reach out.
Thank
Yes.
you
Thank
so much
you.
for your time.
Thank you.
Good night,
Bye-bye.
everyone.
Good night.